All right, good morning, everyone. Court will resume with the October 20th, 2022 docket. And we have Mr. Gorena and Mr. Hinojosa in cause number P0218-22-4 in the case of Ashley Michelle Hernandez et al. Versus Nathaniel Eric Hernandez. Yes, gentlemen.
Judge, Avelino Hinojosa here from Mr. Hernandez also. Judge, he's in my office. He's on the screen also.
Okay, Mr. Gorena, good morning.
Yes, good morning, Judge David Gorena. I know Mr. Hinojosa has taken over the cases, Judge, but I did want to be present just in case there was any questions regarding what the agreement was originally and kind of bring Mr. Hinojosa up to speed on everything.
Who's on the other side?
Okay.
This is the DA's office is on their side. This is the district attorney protective order from the DA's office.
Let me see who's with the DA's office that I have here in the waiting room. Anybody give me some names?
And I have
who's the DA? ADA.
Judge, I'm looking at the email from the extension order. I don't know if she's with the, I don't know if she's a prosecutor now, Blanca Tijerina, or she's maybe with the office.
Yeah, but I believe that's who was present at the last hearing, Judge.
Okay, there's no Blanca Tijerina in the waiting room. And this is why when you get in the waiting room, we ask that you put the cause number or something so we can match you with everybody else and bring you all together at the same time. And people are still not putting their cause numbers next to their names. If you do that, we will immediately bring you in and nobody has to wait 5-10 minutes or anything like that.
I understand.
But I'm doing fishing. I'm doing we're guessing. Yeah. I mean, and then we finish with a case and at the end, 30 minutes later, oh, I'm in that case. Well, if we knew that you were part of that case, we would have brought everybody together.
Can somebody make a call to the ADA?
We've been with this thing like 3 years already. By now, everybody should have learned.
Judge.
Put your case number, put something next to your name. We'll bring you all together. Why do I have to say this every time? And people want to continue with this Zooming business even after we go back to court. So you got to get it right. Otherwise, you're not helping me. Here I am fishing again, guessing who is the other lady. Will somebody call the office and see who it is?
Judge, I'm calling. I have the ADA, the district attorney's office on the line.
Okay.
And Judge, Nereida Singletary represents the, I know she represents the Ashley Michelle Hernandez on the divorce case. And so, but I don't think Ashley Michelle Hernandez is present today either. I don't think she's here.
There's Calistro Hernandez. There is, again, if you put your cause number next to it, I don't care what your name is, I'll bring you in. But I'm having to guess what do we have in this case? An announcement? Did somebody get out?
It's an announcement, Judge. It's a status hearing.
Let's get on with it because that's
it's there for status. Judge, there's a companion divorce case where Nereida Singletary is the attorney. I'm based, and we court ordered us to mediation. We're supposed to mediate this case. And Ms. Singletary and myself agreed to Melinda Diaz as a mediator. Good. I think basically, once we basically go to mediation, most likely, I think everything could be resolved. But of course, the DA's office is not part of the mediation.
Right.
But we'll do order setting hearings. But if there's an extension of this protective order, I mean, we're not going to object to the extension, Judge.
Okay, so it'll be an extension?
Right. I'm not going to alter the terms of the agreement.
And who's going to do the extension? Is that going to be the DA?
It would be the DA's office to do the extension, Judge.
Okay.
Okay, and is it going to be more than 14 days?
No, Judge, I'm in court right now.
Probably, I think it could be more than 20. If by agreement, it could be more than 14 days. That's correct.
Okay.
Miss Cynthia Esquivel will be logging in for the state. Cynthia Esquivel.
Okay.
So that's it. It'll be an extension.
Right here's the state. Cynthia Esquivel. So more than 14 days, they're in agreement.
They're in agreement. Okay.
I think Ms. Esquivel is right there.
Good morning.
All right. Good morning, Mrs. Esquivel. You're on this case, P0218-22-4, right?
Yes, Judge.
And I understand there's an agreement for an extension or something in the protective order.
Yes, Judge. This case was actually reset, Judge. I think that it was just now removed from the docket.
Okay, but I think it's reset for the 31st. Because that's not gonna be enough time because they're gonna mediate, they're gonna try to mediate the case, and there's also criminal charges pending. That's the
Okay.
reason why I don't think,
The 31st of October?
yes.
No, nothing's gonna happen in a week or so. So what do we do with that?
I'm
We're
gonna
fine with
reset it,
extending further, Judge, if that's okay with.
so maybe 45 days.
It'll be an extension, it'll be way beyond over there, right?
Yes.
Okay,
Fine.
all right. You have to be realistic because people want quick settings, they want quick, and you can't mediate like in 10 days or 15 days.
No,
I know
Judge.
everybody wants to feel good about things, but realistically, it takes 45, 60 days. Okay?
Yes, Judge.
All right, guys. Anything else?
No, Judge.
All
Nothing
right.
further.
Remember, put your cause number next to your name and we'll bring you everybody in 5 minutes or 2 minutes. We'll be through with the case. All right. Thank you very much. Have a great day, guys.
Thank you, Judge.
Bye-bye.
Bye-bye.
It's like, Table and Bobby Garcia.
This is number 3.
I'm looking for Bobby Garcia, unless somebody's there for Bobby Garcia.
And I guess here we are. We're fishing again because a bunch of names, 30 names in the waiting room, but nobody has the cause number. So we know Taywell is on this case because he represents the city of McAllen, but who's sitting in for Bobby Garcia?
Judge, for the record, Mr.
Yes, sir,
Austin
Rick.
Stevenson is in the courtroom on number 3, seal 21-2415. Austin
That's the one.
Stevenson.
Who's number 3? Who's there?
Mr. Stevenson.
Good morning, Your Honor. Austin Stevenson. I'm in the courtroom, Your Honor. I had another hearing today, so I came in
Oh.
person.
All right. Good morning, sir.
Austin Stevenson for Bobby Garcia.
Austin who?
Stevenson.
Stevenson. There you go. All right. And so now we got to bring in Mr. Oh, that's Mr. Taywell. Mr. Taywell, can you hear me?
Mr. Stevenson.
He's my co-counsel, Your Honor. He's
Oh,
logging.
he's your co-counsel.
audio.
Okay. Okay. So you're in already. All right. Who's on the other side, Mr. Stevenson? Do you know?
It's Bobby Garcia, Judge.
All right. And do you know if anybody is
Stevenson.
standing in for him?
I do not, Your Honor. He did file a response yesterday afternoon, so I know he's aware of the hearing. I'm not sure if anybody's standing in or not.
Oh, okay.
I'll call
Because
his
I see it.
office.
Okay. I see a bunch of names, but then again, I don't see. I see a lot of lawyers, but nobody's got a cost number next to this cost number, so I can bring you in. So
Okay, we can move on to number 5.
then we're gonna move on to number 5. We'll get you all in a little while, okay?
Thank you, Your Honor.
Thank you. Number 5. I'll call the case after. Would that be like Willie?
Yes, for appendix. And Jesus Chapa.
All right. Next case here. Court will continue with the October 20th, 2022 docket. And number 5, CL 21-4187D. Okay, I see Mr. McCallan, but I see that Jesus Chapa is connecting. And I'll call the case completely after Mr. Chapa comes in. All right, Jesus Chapa is still connecting.
He's got on.
I think he's on. He needs to unmute now.
Good
All
morning,
right.
Your Honor.
Morning. I think we're here on the October 20th, 2022 docket, CL 21-4187D, Rosemary and Josito Dunn versus American Risk Insurance Company. And that's my number 5. I see Mr. Willie McKellen and
Good
Mr.
morning, Your
Jesus Chapa. All right, good morning. What do we have here? Appointment of an umpire?
Yes, Your Honor.
Okay.
This is
Is
case-
your motion, Mr. McKellen?
Yes, Your Honor. It's a case where the case is an appraisal. The umpires were unable to agree as to an umpire, so we're just asking for the court to appoint one. I've submitted a list for the court's review. I don't know if Mr. Chapa has, but I just, the court can appoint anyone they want, someone from our list or their list or someone of their own choosing. So that's all I'm asking.
Okay, Mr. Chapa?
Judge, we oppose the appointment of an umpire. We agree that an umpire is needed. However, the policy requires that the appointment of an umpire be made by a district court judge. We had this issue before, and with Judge Palacios' court, about 2 months ago, and Judge Palacio informed the plaintiff's attorneys that they needed to seek the appointment from a district court because that's what the policy terms dictate. So we're just asking that the plaintiff's attorneys follow the terms of the policy and get the appointment from the district court.
Well, then is this case going to be transferred to a district court?
Your Honor, let me look into that. It may have been filed in
Because if I cannot
some
make a
of the
decision,
new policies do say that. So
yeah,
that's
and if
what
they
it is.
say that and that's what it is, then
Yeah.
it should be district court. But then again, you're here in county court, so you
Yeah.
should then transfer to district court.
Your Honor, I'll look into that, and we could just have a short reset, maybe about whatever the court wants to do.
You want to do a status hearing so you can tell me what's going to happen and what you all
I
did?
need it in writing.
Yeah, give me something in writing so we can set it for status like in 30 days or so.
All right,
And
no
then,
problem.
and then in the meantime, in the interim, if you decide that you should go to district court on your own, file everything and sign everything, and we'll transfer to district court. Okay?
Okay, thank
So
you.
we can
Mr.
dispense with the status hearing. Yeah.
Mr. McCallum also has number 10 of the same thing.
So did you get that, Mr. Chapa? No
Yes,
action
Your Honor.
today.
Is there a date? Okay, that's
No,
fine. Do we
no,
have
I
a
cannot
date
give you a date
for-
because I need something in writing so that I can put a date and give everybody in writing what the new date is. So give me something in writing, giving you a status hearing in about 30 days. I'll leave it blank. I'll put the date in there. And but if in the interim you guys can agree that I should go to some other court, you all sign something agreed on, and I'll sign it and it's gone. Okay.
Thank you, Your Honor.
Thank you very much. Your excuse.
Willie has number 10.
Oh, Willie has another one. Okay. Thank you, Mr. Chapa. Your excuse.
Thank you.
Thank
Thank
you.
you. Y'all have a good day.
You too, huh? What number?
Number 10.
Number 10. Number 10. CL 223067D, Francisco Ramirez versus Southern Vanguard Insurance Company. Okay, we have Mr. Willie McCallum on one side. Who's on the other side, Mr. McCallum?
I have no idea, Your Honor. I don't know if there's.
Okay, I see a lot of names, but nobody's got a.
I don't know if Rachel can run it to see if.
Yeah, Rachel, can you tell me?
That company has used several different lawyers, so I don't
Okay.
have anything here in mind.
You don't know who the latest lawyer is.
No.
All right. Once again, we're here on CL 223067D, Francisco Ramirez versus Southern Vanguard Insurance Company. And we're checking to see if there's another lawyer on the other side of who's the other lawyer. Do you know anybody in the past? Can you mention a name?
I can't remember.
I know it's hard. It's hard to think because you're
Gentlemen.
concentrated on the Astros. I know.
Hey, they won. They had
Judge,
I know it's hard right now.
okay,
Yes,
on
Miss-
this case, there was an answer, response to plaintiff's application to appointment was filed by Joseph Matik.
Okay, Matic, yeah. I mean, he's been on a
Joseph?
few, Your Honor.
Aquí está.
Joseph.
Joe.
Okay, there it is. All right.
Oh, there he is.
All right. Can you hear me, Mr. Matirish?
Audio.
No audio. Okay.
He's connected.
All right. He's already connecting. And
He's got it.
all right. Can you hear me, Mr. Matirish? Mr. Matirish, there you go. Can
Yeah,
you hear me, sir?
sorry. I can. Can you hear me now?
Yes, sir. I can hear you. Good morning.
Good morning.
We're here on the October 20th, 2022 docket, and we're here on CL 223067D, Francisco Ramirez versus Southern Vanguard Insurance Company. And Mr. McCallum is on the other side. He's already on the screen. And it's a hearing on the motion for I think, appointment of an umpire.
Yes, Your Honor.
Yes.
And this is also, it's a case that, it's a damage insurance case on a home. We've requested appraisal. The appraisers weren't able to agree on an umpire, so we're just here asking the court to appoint an umpire.
All right. Yes, sir, Mr. Matiric.
Right. Matedich. Yes, that's right. Yes, I agree. And I've submitted some possible umpires yesterday, and we just asked you to pick from that list.
Okay, great. So both of you already submitted the list, right?
Yes, Your Honor.
All right. I'll go ahead and appoint somebody hopefully today, and I'll let you all know. Okay, guys?
Thank you. Your
Okay.
Honor.
Thank you.
Thank you
that's
so
all I have
much.
before this honorable court, Your Honor.
You all may be excused. Thank you very much. Have a great day, guys.
Go
Bye-bye.
ahead.
Go Astros. All right.
Number 11, 12, and 13.
11, 12, and 13.
And I don't know if it's a moot issue because you already.
All right, let me see here. That'll be, well, let me get the lawyers here. We got Mr. Palacios on one side and Mr. Guerra, right?
He's connected.
Mr. Guerra is connecting. Good morning. Mr. Guerra is connecting. And is that, I think that's it, right, Mr. Palacios? Just you and Mr. Guerra?
That's correct, Judge.
All right. Let me get him on. He is connecting.
Yeah, I have Hector Garcia from Bobby Garcia's office.
Okay.
On
Let me see if
number 3.
Well, Juan Guerra is connecting. He never connected.
There you go.
There he is, Mr. Guerra. Good morning. He needs to unmute.
Good morning, Judge.
Yes, sir. Good morning. And good morning, Mr. Palacios. I think you both are here on CL 223193D, Hector Guerra Construction LLC and all occupants versus CJ Love Inc.
That's correct, Judge.
All
Judge,
right.
as you can recall, this case was heard on September 21st in 2022. The court took it under advisement and signed an order on September 23rd, 2022, dismissing cause of action, releasing the rental payments by this honorable court, and it was signed, as I said, on September 23rd. Thereby terminating this case.
Yes, sir, Mr. Guerra.
Your Honor, I'm a little bit confused. You signed the order for her to releasing the money, and now we're having the hearing. So has the money been removed from the registry of the court? And then why is the purpose of having this hearing if you have already signed the order without a hearing?
Okay. Okay, wait. We have here comes the official response. Go ahead.
There was a hearing back in September. I believe it was on a motion to dismiss
All
and
right.
a motion to withdraw.
Good.
These hearings were already set after that motion was filed. And the reason that these were set further is because on motions for summary judgment, you need 21 days plus 7 days to give them for a response.
Okay.
That's the reason why these were set before. Then they filed that motion and that motion was set before these hearings.
Okay. So why are we here?
Because these were set before, but according to your ruling, then these would be moot.
They're moot then.
Yes, sir.
Okay.
Well, and I still need a hearing. I mean, because the what is set for a hearing, it is right here that it said.
Well, the issues are moot now, Judge.
No, it's not moot, because what this lady did, Your Honor, it went in the middle of the night and forced my client out, literally pulled her out of the house. The cops were called. Ms. Love acted very unprofessional, and that's constructive eviction. That is a felony. It's a felony. She went ahead and called, I don't know who, and her contacts and whatever it happened, but she went in the middle of the night, pulled my client out of the house. Okay. And so I have my client ready to testify. So this is not being moot. I'm going to go ahead and amend the petition and charge her with constructive eviction, which is a felony. In most of the other judges, maybe this court has not had that happen to them, but in all the other judges, they do a penalty of $5,000 because that is constructive eviction. And if this court allows this type of behavior, then we lose control. She didn't have no right. Only a constable can go there and get her out. She pulled her out in the middle of the night. So
if I may, Judge, Mr. Garrett,
I'm not finished yet, sir. Okay, I did not interrupt. I did not interrupt when you were talking. So let's hold on.
All right, just a moment, Mr. Palacios. Go ahead, Mr. Guerra.
And so the question here is that if the money is being given back, she needs to return it because we will go ahead and charge her. We're going to amend the petition, and we're now charging her with constructive eviction. It was not the constable that got her out. It was her in the middle of the night. The constable went ahead and was trying to get her, was serving the writ of possession, which he rightly did so. Before the writ of possession was issued, she went to a district judge, and the district judge went ahead and gave her 10 days and set it up for a hearing. That night, She was served with that paper. She knew about it, but instead she went ahead, and I tried to convince the tenant, which is Ms. Love, and she just went ahead and went all. And she says, no, she can do whatever. I said, okay, man, but you're in violation of not a protective order. And
Okay.
so the problem here is that there's procedures. And so I'm very upset because especially on her, that she's a professional, she's an attorney. And so if this court allows this to happen, I mean, we're going to lose control. There could have been a fine. I told my client, she's a very peaceful lady. She said, no, I don't want any fine. That she went inside and started getting all her stuff and throwing them and breaking all her stuff inside the house. My client is ready to testify. This cannot be allowed, Your Honor. And so that's why it's important that I either don't dismiss this case, I'll amend the petition, and you can see the constructive eviction. It's very clear. It's very clear, Your Honor.
Okay.
Thank
Mr.
you.
Palacios?
Judge, if Mr. Guerra wants to talk about professionalism, Mr. Guerra tried to forum shop and try to refile another challenge on this position. He wasn't happy with this court's ruling, tried to reopen this case in the 398th until we let the court know in the 398th of this court's ruling with the court then threw out Mr. Guerra's petition, admonished him, and we could have filed sanctions. We could have challenged him. We could have filed a claim for frivolous lawsuit. We didn't, out of respect, out of courtesy. We are honoring this ruling. We are trying to put this to bed. We're trying to put this to rest and move on from these proceedings. If Mr. Guerra wants to proceed however he wants to, that's his business. However, these issues are moot at this point, and we ask the court to proceed as such.
All right.
You're
And
right.
so, Mr. Guerra, you're going to amend your pleadings, and then we'll probably have another hearing or something. Is that what you want?
Yes, I'm going to amend the pleadings to go ahead and sanction her or do whatever I need to do. And I told they did tell me that they could sanction me, that I was foreign cop shopping, and I said, okay, you have every right to do that. Sanction me, do whatever you need to do. But
Okay.
that does not give you a right to go in the middle of the night and pull literally grab my client from inside. She opened the door, knocked the door, and literally grabbed her arm and pulled her out of the house. That's
Okay.
That is not very unprofessional. So
All right. So then
want
today
to amend
there's
the
no.
petition.
So then today there's no action because we're going to be awaiting what the pleadings are going to be, and
Yes,
then we'll
sir.
set it for hearing.
Yes, sir, Your Honor. Thank you so much.
All right. Then thank you all very much. You all may be excused. Have a great day.
Thank you, Judge. Have a wonderful day, Judge.
All right.
Number 3.
Number 3. Oh yeah, let's go back to number 3, Mr. Taywell.
Mr.
And
Stevenson.
I'm sorry, Mr. Stevenson, and who's gonna show up? Hector
Garcia.
and Mr. Hector Garcia. Okay, this is yes.
Sorry, Your Honor, Isaac Twill is on. He's indicating to me that he's unable to mute or turn on his video, that it says only the host can do that. So I don't know if whoever's hosting the Zoom can allow Mr. Twill to turn on his video.
No,
Not
he's
you.
the one that has it off.
Okay, I'll let him know. Thank you. He's getting an error message.
Okay, so we're here on the October 20th, 2022 docket, CL 21-24-15D, Olga Villarreal versus the City of McAllen. Okay, do we have a plea to the jurisdiction?
Yes, Your Honor.
All right.
Good morning,
Yes.
Austin Stevenson for defendant, City of McAllen.
Yes, sir. Good morning.
Your Honor, Hector Garcia for the plaintiffs from the law office of Bobby Garcia.
All right, good morning.
I'm here for Bobby Garcia.
All
Good
right.
morning, Your Honor. This is a really straightforward plea. I don't know if the court's had a chance to review it. A response was filed yesterday. It's a pothole case, Your Honor, that took place on 2nd Street. Basically, what our plea alleges is that the pothole is nothing here raises to the level of a special defect. It's just a normal pothole. It's a plea to the jurisdiction because it's the City of McAllen, and of course, the city has governmental immunity under the Texas Tort Claims Act. Here, the plaintiff was driving on 2nd Street and had a flat tire after she went through a pothole. The city has since, of course, fixed the pothole in question. even if the plaintiff were to allege anything to show that this was a special defect, the city has a reasonable time to fix the defect, to repair it, to make it safe. So that's where we are, Your Honor, is one, there's no evidence to show and no allegations that this was a special defect, just the plaintiff's self-serving allegation that says it was a huge pothole. And two, there's nothing to show that there was a report that was made prior and the city failed to fix it. This is the first notice that the city had of this incident. There's nothing, discovery's already been conducted, written discovery and depositions. In plaintiff's response to our plea, they do state that we cannot rely on our disclosures in order to create a fact issue. That's correct. We're not creating a fact issue. We're simply pointing to the fact that there was no notice. Had there been notice, that report would have been provided in the disclosures. And so we're not creating a fact issue, Your Honor. In fact, there's no reason even to get into the material facts of the case. All we need to look at is that there's no special defect here. And it's well established that a pothole cannot be a special defect unless it's an extreme situation. For a matter of public policy, if a city had to pay for every time somebody got a flat tire in a pothole, would be bankrupt. And I'll leave it at that, Your Honor. I believe you've probably heard several pothole cases in your time on the bench, so I'll let you review the pleadings and response, and I'll allow opposing counsel to respond.
All right, Mr. Garcia.
Yeah, before I respond, I just want to let the court know and the opposing counsel, we filed a first amended petition yesterday. So are we here on the first amended petition, or are we here on the original petition?
Your Honor, this isn't special exceptions. This is a plea to the jurisdiction. So there's nothing that changes the facts and the discovery, no matter if they changed, filed an amended plea. And I did see the filing come through. This would be the second amended petition. So I believe that's erroneously labeled. Our plea is to the first amended petition. I believe this really should have been the second amended petition. But regardless of what the new filing is, the evidence and discovery will speak for itself, and the attachments to the plea to the jurisdiction. I cite in my plea, Your Honor, the case law, which establishes that it's proper for the court to consider that evidence while deciding this plea. I also cite the fact that when we're talking about special defects, it is not a question of fact for the jury. It is appropriate and necessary for the court to decide at the plea to the jurisdiction stage as a matter of law whether a special defect exists.
Your Honor,
just throw me everything, sir. Throw me everything you got.
Yeah, first of all,
We share a petition, or all of them together. Doesn't matter.
Yes, first of all, regarding to the plea jurisdiction, the court has to allow the plaintiffs an opportunity to amend their petition. So having said that is required. Now, I totally disagree with opposing counsel's arguments, and let me explain. We file a response, and in our response, we file Exhibit 1, which is an affidavit of our client, and we also file Exhibit number 2, which is the police report, and Exhibit number 3, which is photographs of that particular section of 2nd Street where it has the potholes. In fact, it had many potholes, and the photos, Exhibit number 3 shows that they were being repaired. And let me tell you a little bit about the facts of the case. And this is, you have to intertwine the facts of this case in the plea to the jurisdiction. Our client on January 19 of 2021, thereabout, was traveling northbound on South 2nd Street when suddenly and unexpectedly hit one of the potholes that was there, and it damaged her vehicle, and it damaged the wheel of the vehicle. In fact, she had a flat, and because of that, they sustained injuries. Now, if you look at her, also I want to offer defendants Exhibit B, which is a deposition of our client, where in there she's making those statements that I'm saying at this particular time. Now, it's not just a special defect, it's also a premise defect. And under the Texas Torts Claim Act, Civil Practice and Remedies Code 101.022, it talks about premise and special defects. Subsection A deals with premise liability, and subsection B special defects. It creates a duty of a licensee under the premise liability A, and it creates a waiver for plaintiffs to be able to sue the city. So we have that premise defect there scenario. And on this case, I also asked the court to look at the police report. They had notice. In fact, our client's accident was the third accident. And if you look at the police report and read the police, it states it there. The police officer states, I was dispatched to 2 prior accidents at that location. And it was not until our client's was the third one that the police officer decided to go ahead and call the traffic department to send somebody up there. Hey, we gotta take care of this issue. Now, I'm putting the police officer works for the city, so he's an employee of the city. When he went to the first accident there, or the second accident, he didn't put any signs, warnings, or barricade, say, hey, stop, don't come through here. You know, so that's sufficient notice. I mean, he's a patrol cop. He should have put something there or directed traffic. When my client had her accident, he was not there. He had already left. And you can look at plaintiff's exhibit, defendant's exhibit B, which is a deposition of my client, where it states that there was no police around, there was nobody was giving directions, there was no warning signs, there were no barricades on it.
No cones.
Exactly, nothing there. And that's under page 33 and 34 of her deposition, where she's making those statements. So they had notice. We're alleging premise defect. We're alleging special defect. And under the premise defect, the city of McAllen knew because the police officer knew. And our client did not know. So that establishes the premises defect under 101-022A. And a special defect is also there because it's an excavation. And those are material facts of the case, and that the court has to consider. It's not just on the law, on the facts. And secondly, we gave him fair notice of what was there in our petition that we filed on the first and on the petition, the first amendment, and so forth. And we filed a second amendment to clean it up better than the first two.
Okay, thank you, sir. Mr. Stevenson?
Yes, Your Honor. So one clarification, or a couple clarifications. The plaintiff did testify that there was not another officer on scene, but it was dark. There weren't other police officers there. However, there's no reports of this pothole to the city prior to this incident. And while there were 3 consecutive accidents, these were not accidents, but incidents, flat tires. We had claims come in, 3 claims total, Your Honor. This is the 3rd one, but they occurred consecutively. The city needs a reasonable time to fix the pothole. They can't just magically fix the pothole after one. Second Street is a heavily traveled area. And so it happened consecutively, one after another, flat tire, flat tire, flat tire, they're responding. And then the second thing, Your Honor, that I'd like to clarify is with the word excavation that was just used. That's a very specific term under the Texas Tort Claims Act and the Civil Practice and Remedies Code, and a pothole does not rise to the level of excavation. Further, plaintiff's self-serving testimony and affidavit is not enough to overcome the fact that this is a pothole on a city street that caused a flat tire. And that there was actually no, even if it were a special defect, which the defendant denies, there has to be allowed a reasonable time to fix said premise defect, or excuse me, special defect. When we're looking at premises liability, it is a licensee standard. And in order to prevail on a premises defect claim against municipality when it comes to potholes, they have to establish it was a special defect.
Your Honor,
Okay.
in response to that, Your Honor, my whole point is that if well, first of all, my client claimed he was not there and there were no signs and no barricades, and it happened. And my whole point here is that he's a police officer. When an accident happens, they redirect traffic. They stop
Okay.
and say, you detour, you go there, and he's an employee of the city. So
Right.
the city is on notice that there's something wrong there. You know, he just can't leave the scenario, cannot leave the scene and expect another driver to come by and notice what was going on.
Okay.
Your Honor,
Okay.
if I may, just quickly, I know, I just
I'm
want to
not finished
clarify.
yet. Let me finish.
Just
Okay,
quickly,
Mr. Garcia.
Yeah.
we can't have police officers sitting
Look,
next to me. Sorry.
Look, I think what Mr. Garcia is really alluding to is that although there's 3 accidents or 4 or whatever, that and although the city needs time to repair the matter, you still needed to put some kind of barricade or a warning sign or a cone or something to make sure that the 4th car wouldn't come in there, right? I think that's the main your argument, Mr. Garcia. What I was going to say is I've heard enough already. Let me go ahead and take it under advisement. I will review all the exhibits, all the affidavits, and come up with a ruling sometime next week.
Thank you, Your Honor.
Thank you.
Okay. Thank you very much. Have a great day. Bye. Bye-bye.
Thank you. May we be excused?
You all may be excused. Have a great day.
Thank you, Your Honor. Stay safe.
Yes, sir. Stay safe.
Thank you for allowing us to come in this morning. Thank you for coming in.
Let's see who's going to go next. I see Mr. Orozco on the screen. Let me see.
Good morning,
here.
Your Honor. Yes, we're present and ready. How are you today?
Oh, fine. Thank you, sir. Good to hear from you. And let me see. I think it's number 15 then?
Yes.
F3958-21-4. In the matter of the marriage of Valdemar Renteria and Maria Contreras, it's a final divorce. Okay, now where is respondent?
Your Honor, I'm not sure. I'm looking at the order setting final hearing. It appears that notice was sent to her, same as to me, to Ms. Maria Y. Contreras at 6361 Old La Blanca Road in Donna, Texas, 78537, Judge.
Okay, and
Okay,
so
maybe she's using somebody else's.
yeah, there's Ruby's phone here. Let me see if it's her or not. And
Let me see who this is.
I need to guess and see who if she's using somebody else's phone or something. There's yes, Miss
No audio here.
okay, she has no audio. Do you recognize her? Is she the respondent by any chance?
Is that her?
Yeah, that's right.
Yes, that is her.
All right, she's using somebody else's phone number. That's what it is.
And G, Mr. Galindo, what case is he on?
Yeah, Mr. Galindo, which is your case? You need
No,
to.
he's got
Okay.
It's
We got it.
with Lucy.
All right, we'll call it in a little while. We'll call Mr. Galindo's case in a little while. One moment. All right, we're here on F3958-21-4 in the matter of the marriage of Valdemar Renteria and Maria Contreras. It's set for final divorce, Mr. Orozco?
Yes, it is, Your Honor. And just wanted to advise the court. I contacted the Attorney General yesterday. Apparently, there was a prior Attorney General case. I had also notified them and had asked them to intervene. I spoke with a lady by the name of Blanca de Leon, who told me that she saw my notice of representation, but that they were probably not planning on intervening, that they were not going to be present. What I managed to obtain is also an arrearage amount that's owed based on their history. And we're ready to proceed if we can finalize it today. If Ms. Maria Contreras wishes to finalize it, we're ready to proceed, Your Honor.
Okay, Ms. Contreras, can you hear me?
Yes, I can hear you.
Okay, do you have an attorney, ma'am?
No, I don't.
You never got one. How long is this case? This case is 415 days old and you don't have an attorney, right?
No, because I didn't see the need to do so.
Okay, that's your prerogative. That's fine. You can do that. But we're set for final hearing already. Are you ready for final hearing?
I've been ready since the very first time we went into the call.
Oh, okay. So, Mr. Orozco, you ready?
Yes, we're ready to proceed, Your Honor.
Okay, let's get it done here. Any children in this marriage?
Yes, Your Honor. There's 4 children.
Okay.
That would be Angelica Maria Renteria, Valdemar Renteria Jr., Catalea Renteria, and Bella Renteria, Your Honor.
She never had an attorney in those 415 days. My question is, did you all ever talk to try to settle this matter or anything like that?
Yeah.
Your Honor. Yes, Your Honor. There was some communication. We filed an order setting hearing back on July of this year. One of the matters was we were waiting for the Attorney General to intervene or not intervene. And since they decided not to, but I have obtained, obviously, the records, and
Yes.
we're willing to stipulate to those as far
All
as the
right.
arrearage is concerned. Yeah.
That is correct. That's what you said earlier, that you were
Yes.
waiting on those numbers.
Yes, sir.
Okay. Then you want to call your client as a witness?
Definitely, Your Honor.
And that'll be Valdemar Renteria, right?
Yes, sir. He's sitting
Well,
right next to me, Your Honor, Judge.
All right. Court will continue here with the October 20th, 2022 docket. And we have here once again F 3958-21-4 in the matter of the marriage of Renteria and Contreras. Please raise your right hand, sir. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may put your hand down. Mr. Roscoe, you may begin.
Thank you, Mr. Renteria. Please state your full name for the record. Your name for the record.
Valdemar Renteria.
Okay, and are you the petitioner who filed a petition for divorce?
Yes, sir.
And you filed a petition for divorce because of discord and conflict of personality?
Yes.
And there is no reasonable expectation of reconciliation?
No.
All right. And there are 4 children born of the marriage. Is that correct?
Yes.
You heard me state those names for the record when the judge inquired. Is that right?
Yes.
All right. Now, prior to this hearing today, there was an attorney general's case in which you were already to pay certain amount of child support. Is that correct?
Yes.
And you have been making certain payments. However, you do recognize that you're in arrearage, still owing $4,626.18. Is that correct?
Yes.
And are you asking that part of this divorce, that this court enter a divorce decree reflecting the amount of arrearage and the amount of child support?
Yes.
Now, you're indicating to this court that based on those 4 children, you are in agreement that the children continue to remain and reside with Miss Maria Contreras. Is that correct?
Yes.
And for you to have visitation as per the family code under the standard possession order?
Yes.
All right. And based on your wage calculations, are you asking that you be ordered to pay child support in the amount of $1,407 starting on November the 1st of 2022?
Yes.
And you're asking for step downs as per the family code once the oldest child emancipates. Is that correct?
Yes.
Now, you're also asking that on the amount of judgment and arrearage of the $4,626 for you to be ordered to pay an additional $150 a month until you finally liquidate that amount. Is that correct?
Yes.
Now, there was no property that was obtained by the parties. Is that correct?
No.
The only property that was obtained was any personal belongings, and that personal belongings each of the party has in their possession. Is that correct?
Yes.
You're asking that this court, as far as as part of the divorce decree, order each of the parties to be responsible for any debts associated with any personal property that they have kept. Is that correct?
Yes.
All right. And you're asking for a divorce at this time?
Yes.
Judge, I don't know if Ms. Maria Contreras ever had changed her name to Renteria or not, or if she wishes for me to have the divorce decree reflect her last name changed to her maiden name of Contreras.
Ms. Contreras, did you ever change your name?
No, sir, never changed it.
Okay, it's always been Contreras, so we leave it alone.
Okay.
Okay. Anything you want to say, Ms. Contreras? I mean, is that you agree with what they were testifying to?
I've never wanted anything and never the best that I ever had are my children. And that's all I've ever wanted to stay with me because they're in the best hands. He knows that I work my ass off for those kids. I live for those kids. That's all I want, just for my kids. For him to take children, especially the oldest ones, before he loses. That's all I'm asking.
Okay, so as far as the child support amount and all those other numbers, figures they put in the record, you have no problem with that, right?
I don't care about none of that.
Okay, then good luck with the divorce here. Court will take judicial notice of the entire file of the case. Court will go ahead and grant the divorce as requested by the parties. Court will accept the numbers that were read on the record, and court will await a decree for signature. Anything else, Ms. Contreras?
Yes. See if Mr. Renteria is also de acuerdo, I would want to waive the 30 days.
Oh.
Like the 30 days wait of after the divorce where
For getting married?
Nos arrepentimos. Yo no me arrepiento.
You need to speak in English, ma'am.
No, ma'am. No, ma'am. You say you wait 30 days for what? What do you want those 30 days?
The 30 days after the divorce. You know how you have to wait 30 days after you divorce if you want to reverse it? I
Oh,
want
no,
to.
no. We can't do that. We can waive him if you're going to get married, but we can't waive civil procedure here. That's up to the code, family code, or rules of civil procedure. So, I mean, no, we just leave it alone. We just go ahead and sign the decree. And within those 30 days, if anybody wants to file a motion for new trial, go right ahead, but doesn't mean it's gonna get granted. But no, we'll go ahead and just await a decree for signature. And once we sign the decree, everybody will get copies, okay?
Yeah.
All right, good luck you all. Thank you very much.
Thank you, Judge. I'll
Don't make
prepare the
excuses.
order and submit it. Yes, Your Honor.
The
Thank you.
decree, okay, sir?
Yes, thank you, Judge.
Thank you, bye-bye. All right, what's next? What 30 days?
This gentleman, he has a, the default,
Give me a case, give me a number.
number 4.
Yeah. Let's see here. Number 4. Who we have here? Court will resume with the October 20th, 2022 docket. CL 212430D, River City Produce Company Inc. versus Amore Produce LLC, and it is a default hearing. And I think we have Mr. Patel on the screen. Can you hear me, sir?
Yes, sir, I can hear you.
All right. Good morning, sir. It's your case, right?
Yes, sir.
All right. Then court will note that Amore Produce LLC is not anywhere in the waiting room nor in the courtroom because they would advise me. So therefore, court takes judicial notice of the entire file, and you may proceed.
Your Honor, this is our motion for default. Your Honor, it's a subrogation file whereby our client had paid fees. Central Mutual Insurance paid its insured River City Produce. And now we're trying to recover from the defendant, Amore Produce, for damages as a result of a vehicular accident. And so we are simply asking the court for a total of $13,201.75. The motion for default, as well as a citation, has been on file for longer than 10 days. And thus we are entitled to a default. We are unaware of any answer or any appearance made by Amore as far as we're aware.
All right, court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requests to hear in open court or in its petition. Court will await a default judgment for signature. That'll do it, sir. Thank you very much. Your excuse. Have a great day.
You too, sir. Thank you for your time.
Thank you, sir. Bye-bye.
Bye-bye.
Bringing in Mr. Maguire. I don't know what case he has.
All right. There's more default hearings.
Yes.
Mr. Maguire, good morning, sir. Can you hear me?
Yes, I can. Yes, good morning. Can you hear me?
You need to raise your volume, sir.
Yes, raise your volume. I can barely hear you.
Can you hear me better now?
Now a whole 150% better, Mr. Maguire.
Great.
Mr. Maguire, which is your case?
My case is Ford Motor Credit versus Roberto Rodriguez Vasquez.
Got it. Court will continue here with the October 20th, 2022 docket, and we have CL 221180D Ford Motor Credit Company LLC versus Roberto R. Rodriguez Vasquez. Court will note that Mr. Vasquez is not in the waiting room nor in the courtroom. Therefore, court takes judicial notice of the entire file, and you may proceed, sir.
Thank you, Your Honor. The defendant purchased a 2016 Ford F-150 on November 22nd, 2016 by written agreement with Bogus Ford Sales Incorporated. This written agreement gave the plaintiff the right to repossess the vehicle in the event of default. The payment arrangement to purchase the vehicle were 75 monthly payments at $972.82 per month starting January 6, 2017. The last payment received by the plaintiff was on July 28, 2020. This was the event of default. The vehicle was never repossessed by the plaintiff or sold at auction. It was never recovered. After all lawful credits and deductions, a deficiency amount remains due and owing in the amount of $36,535.57 for which plaintiff seeks judgment, plus court costs and attorney's fees at $250 per hour for 2 hours of legal work. This legal work is considered reasonable and customary for a total of $500. The plaintiff also requests the court to change the amount shown on the default judgment. The amount should show an attorney fee for $500. That was an error. We apologize. Nothing
Fees.
further, Your Honor.
Okay, fees of $500 fees.
$500, yes, Your Honor.
That is what it should be. Okay.
Yes, Your Honor.
On an amended judgment.
You want to change it yourself? Or you go with
On
the-
the amended judgment.
Okay, Mr. McGuire, can you please file an amended judgment?
Yes, we can. We can do that. Yes, sir.
Excellent, excellent. Court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief request to hear in open court or in its petition. Court will await a default judgment, an amended default judgment for signature. All right, thank you very much, sir. Thank you for waiting. You may be excused. Have a good day.
Thank you, Your Honor. You too. Thank you.
Bye-bye.
See what Mr. Daniel Taylor has.
Who?
Daniel Taylor.
Okay. All right, Mr. Taylor, can you hear me? All right, you need to unmute Mr. Taylor.
Can you hear me?
Yes, sir. Now I
All right,
can hear you.
perfect.
Good- Yes, sir. Good morning, sir. Which is your case?
My case is going to be, let's see here, it's CL 221125-D.
Okay, and you only have one case?
Yeah, yes, Your Honor.
All right, that'll be cause number CL 221125D, Security First Federal Credit Union versus Fernando Marquez. Court will note that Marquez is not in the waiting room nor in the courtroom. Therefore, court takes judicial notice of the entire file, and you may proceed, sir.
Yes, thank you. Plaintiff moves to enter all documents and evidence, and we're seeking default judgment in the amount of $13,748.56, as well as court costs and post-judgment interest.
All right, court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in its petition. Court will await a default judgment for signature. That'll do it, sir. Thank you so much for waiting. Your excuse. Have a great day, okay?
You too. Thank you, Your Honor.
Yes, sir.
Michael and you.
All right. Maybe he was going to be doing Willie's case. All right, Mr. De Leon is connecting. You don't see his name anymore?
No.
Okay.
He's got on.
Okay, Mr. De Leon, you need to unmute.
Okay, Judge.
Yes, sir. Good morning, sir. Mr. De Leon, which is your case?
Judge, it is Josito Dondon. It's CL2-4187D.
Okay, we already called it about an hour ago, and I think it was Mr. McAllen who showed up.
Okay, okay.
It's over. It's done with. Okay, sir?
Very well, Judge. Thank you.
All right. Thank you so much. Your excuse. Bye-bye.
Thank you. Bye-bye.
Number 8,
Who's that going to be?
Mr. Whitney.
Okay.
Reyes.
Okay. All right.
That's number.
All right, Miss Reyes, there you go. Good morning.
Good morning.
Yes, ma'am. Of all the attorneys this morning, you're the one that actually put your cost number next to your name and your style of the case. Perfect. That's the way everybody should do it, okay? And I think you're here on Discover Bank versus Jenny Garcia.
Yes, Your Honor.
Only one case, right?
One case.
All right. Court will continue with the October 20th, 2022 docket. And we're here on CL 22-1546D, Discover Bank versus Jenny M. Garcia. Court will note that Garcia is not in the waiting room nor in the courtroom. Therefore, court takes judicial notice of the entire file, and you may proceed.
Okay. Plaintiff's default judgment stems from a breach of contract suit filed on April 29th, 2022, after defendant defaulted on the account by failing to make payments when due. Defendant was served on May 25th, 2022. Return of service has been on file for the prerequisite amount of time. No answer has been filed. Plaintiff's motion for default judgment was filed on July 26, 2022, and was sent to defendant via regular mail. Notice of this hearing was also sent to defendant on September 20th, 2022. We're asking the court to take notice of the file and requesting default judgment in the amount of $3,320.47. with court costs of $448.35 and post-judgment interest of 5.5%.
All right, court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in its petition. Court will await a default judgment for signature. That'll do it, ma'am. Thank you so much for your patience, your excuse. Have a great day, ma'am.
Thank you, Your Honor.
And Mr. Fonseca, that's for number,
Mr. Fonseca.
that is number 14.
All right. All right.
We're waiting on Miss Lucy.
Okay.
And
What about Ms. Dominguez? Mr. Fonseca, good morning, sir.
Yes, sir.
Your wait. Yes, sir.
I just wanted to let the court know that Ms. Del Bosque, she's the amicus attorney. She has CW court at 10 and 10:30. I don't think she'll be back until about 11. I'm not sure if the court has business.
Okay.
they can attend
I don't
to.
think we'll, unless we really need her. I mean, if we're gonna do a final, is it set for final today?
It's set for final today, Judge. And we agree on pretty much, I don't want to get into too much, but we agree on almost everything except for child support. I don't think it'll take longer than 10, 15 minutes, Judge, as long as we can get everybody on just to explain why they feel that it should or shouldn't be there.
Okay. Okay. So on the other side is Ms. Williamson?
But that's correct, Judge.
Was she on earlier?
no,
Okay.
she called the court that she's busy in another court.
Okay, she's busy in another court. Okay, we'll be on standby here for a few more minutes. I'm gonna get to somebody else. Okay, sir?
Of course, Judge.
Okay, thank you.
Ms. Dominguez,
Ms. Dominguez, attorney for Yolanda Aguirre. Okay, let's look for Yolanda Aguirre or,
No, I'm sorry, Your Honor, that's incorrect.
oh,
I didn't
okay,
sign in.
okay.
I'm for Bank of New York Mellon.
Okay. Melon. This a produce case?
number 2.
Number 2. Okay, we found it. Okay, we found it. It is CL 203488D, the Bank of New York Mellon Atoll. There's a lot of people in there. It's a gang versus Ramon Alvarado and all occupants. Is it an MSJ, motion for summary judgment?
That's correct.
Okay, now, I don't have you here, but you're the attorney for the Mellons?
That's correct, Your Honor.
Okay.
Daniel
Ms.
Vargas is-
Dominguez. All right, now, Daniel Vargas is on the other side?
Yes.
Because I don't see Daniel Vargas in the waiting room nor in the courtroom. And
Did he file a response?
did he file a response?
He did file a response, Your Honor.
Okay. Yeah, let me just give him a little courtesy call here to see if he's gonna show up or not or what. Or we can do it under advisement and we can take it by submission, whatever. Let's see what we're gonna do here.
That's
Like I
fine,
said,
Your
I don't
Honor.
see him, anywhere, so
We're gonna call him.
we're gonna try to call him. So hold on a few minutes there, okay, man?
That's fine, Judge. Thank
All
you.
right, thank you. Al. All right, Ms. Dominguez.
Yes, Your Honor.
All right, Ms. Dominguez, we're here on the October 20th, 2022 docket, and your case is Bank of New York Mellon versus Ramon Alvarado et al. In cause number CL 203488D. It is your motion for summary judgment. I haven't heard from Mr. Vargas, but he did submit a response.
That's correct, Your Honor. He did.
All right, what I can do is I can rule on this by submission.
That's fine, Your Honor.
I haven't heard from him or anything like that. I know they had him on the line earlier or something, but I need to hurry because I got another matter exactly. I have a meeting at 12 o'clock, but I also have a family law case I need to hear it later on. So I'll do it by submission and submit your proposed orders, okay, man?
Yes, I will. Thank you,
Or
Judge.
judgments in this case. Thank you so much. Bye-bye.
Bye-bye.
Who's gonna get next? Are they parties or who are the lawyers? I don't see any lawyers on the.
Just that Mr. Fonseca, we're waiting for Miss Lucy
Okay,
Williamson.
okay.
And
Ms. Ayala.
Court will resume with the October 20th, 2022 docket. Mr. Fonseca, I know he was on earlier.
Yes, Judge, I'm
There
here.
he is, Mr. Fonseca. I'm trying to get Lucy Williamson to get on board, but she's on a highly contested hearing on the 93rd case at court.
That's my understanding, Judge. I also was in contact with Ms. Cynthia Del Bosque. She's unable to appear at this time because she's got a contested hearing in CW court.
Okay. So then for the day right now, I can't do nothing. I have a judges meeting at 11:30 that I
very
gotta
well.
get ready for. So I can't do anything right now. Just we'll reset it. You'll be hearing from my court coordinator, and she'll give it a setting.
Yes, Judge, I'm already in contact with her. I'm gonna file an order setting hearing today. I
All
think
right.
we can get accommodated quickly.